Hey, welcome back to the channel. My name is James. If you're building a business, an app, a product, or any service that uses people's personal data, you've probably heard of the term DPIA, which stands for Data Protection Impact Assessment. It sounds like another compliance box to tick, but it's actually a structured way to find and reduce privacy risks before they become a real problem. In the UK, it's a legal requirement in certain situations, and getting it wrong can mean serious fines. So in this video, I'm going to break down what a DPIA actually is, why it matters, and how it is used. All of this based on the official ICO guidance in the UK GDPR, which I've linked in the description. Let's dive in. What is a DPIA? A DPIA is a process that helps you systematically analyze, identify, and minimize the data protection risks of a project or plan. It's part of your accountability obligations in the UK GDPR. It doesn't have to remove every single risk. The idea is to minimize risk and decide whether what's left is acceptable given what you're trying to achieve. DPIAs are meant to be flexible and scalable. They can apply to a wide range of sectors and projects. They don't have to be huge or time-consuming every single time, but the level of rigor should match the privacy risks. Low-risk processing might need a light touch assessment. High-risk processing needs something more thorough. There's no single official template that you're forced to use. The ICO provides suggested templates you can use, or you can develop your own as long as it does the job, using the ICO's guidance as your starting point. I have linked the ICO templates in the description of this video. Why DPIAs matter? First, the legal bit. Doing a DPIA is a legal requirement when you're doing processing that is likely to result in a high risk to people's rights and freedoms. If you don't do one when you should, you can face enforcement action from the ICO, including fines of up to 4% of your global turnover. So this isn't optional when processing is high risk. DPIAs also support another obligation under the UK's GDPR, data protection by design and default. That means building in privacy from the start. At the time you decide how you're going to process data and when you're actually processing it, not bolting it on afterwards. Doing DPIAs regularly help your team think about privacy early and builds that by design approach into how you work. Beyond compliance, a good DPIA helps you spot and fix problems early. That means less cost and less reputational damage than dealing with a breach or complaint later. It can also reassure people that you're thinking about their data seriously, and in some cases, the consultation part of a DPIA gives stakeholders a chance to have a say in how information is used. So it's not just a paperwork exercise, it can improve trust, transparency, and the way you handle data. How DPIAs are used. A DPIA can cover one processing operation or a group of similar ones. You might be able to use or adapt an existing DPIA if you've already assessed something similar with similar risks. For new tech, you might use a DPIA from a product developer to inform your own assessment of how you're going to use it. You can weave a DPIA into your normal project management. For new projects, it's a core part of your data protection by design. You do it when there is still real scope to change how the project is developed and implemented. But DPIAs aren't only for brand new systems. If you change an existing system, you still need to do a DPIA at the point where you can actually influence the plan. The outcome of the assessment has to be fed back into the measures you take. So DPIAs are not just rubber stamps, you actually use the results. And a DPIA isn't a once-off document you file and forget. It's a living process. You need to keep it under review and reassess when things change. For example, if you change how or why you process data, how much you collect, or if something in the wider context shifts, like new security flaws, new technology, or new concerns about the type of processing or the people affected. What risk means. The UK GDPR doesn't define risk in one neat sentence, but the DPIA provisions make clear when talking about risks to individuals' rights and freedoms. Article 35 says the assessments have to consider risks to the rights and freedoms of natural persons. This includes privacy and data protection, but also other fundamental rights and interests. Recital 75 spells out that risks can be physical, material, or non-material harm. For example, discrimination, identity theft or fraud, financial loss, damage to reputation, loss of confidentiality, or other significant economic or social disadvantages. So it's not only about did someone lose money, it's a significant impact on people. The level of risk depends on how likely the harm is and how serious it would be. So to tie it all together, a DPIA is a process to analyze and minimize data protection risk before and as you process personal data. It is a legal requirement for high-risk processing under UK GDPR, supports data protection by design, and when done properly, it helps you comply and demonstrate that you take privacy seriously. It's flexible and scalable and should be a living process that you keep under review. I've left links in the description to the ICO's full DPIA guidance, their templates, the relevant UK GDPR articles, and the ICO's guidance on fines, all primary sources so you can check exact wording for yourself. Thank you for watching, and I'll see you in the next one.